Okay.
All rise. Court of Appeal in for the 5th District of the State of Florida is now in session. Counsel Vincent G. Torpey Jr., Chief Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America and the state of Florida and this honorable court. Please be seated.
All right, gentlemen, you're our only case on the docket this morning. And
Must be a really interesting one, given the audience that you've drawn.
you know Judge Griffin to my right, you know Judge Orfiger to my left, and so with that, we'll go ahead and call the case, and it's NIEDERHELMAN. Okay, all right, sir, fire away.
May it please the court. My name is Nick Shanine, and I represent the appellant in this matter, Donna NIEDERHELMAN. The issue in this case is straightforward: whether the lower court abused its discretion by failing to order a new trial when the jury did not award a single dollar to the plaintiff when liability was uncontested and all of the pre-surgical damages were opined by every medical witness who testified to be reasonable, related, and necessary, including the defendant's IME.
Mr. Shanine, we've had a lot of cases over the years where judges dismiss cases pre-trial for fraud on the court, where there's a lot of misrepresentation and prevarication and sometimes flat-out lying. And I think Judge Griffin wrote an opinion not too long ago that said that it's usually a jury function, as long as the lying isn't all that bad, it's a jury function to impeach the defendant with his or her prior issues. Isn't that precisely what happened here? And the jury just didn't buy what she was selling?
Your Honor, first let me agree with the posit that there is a mechanism for dealing with fraud. Fraud is its own issue, and Cox v. Burke, a famous case by this court, made clear that actually courts do have the ability to, under the appropriate circumstances, move those cases out of the stream when that fraud is apparent. But where it's a question that gets to the jury does have the opportunity to weigh credibility, of course, and to use those credibility determinations against a plaintiff who is not being truthful. But where there is a line, that line occurs where in order to use a credibility determination, you use it in a way that overwhelms the facts, overwhelms the unrebutted medical evidence, overwhelms everything just to say, you're a liar, you should lose. In this case, we very much believe that that's not at all what the case is. But the important part of this is that there is a line, and that line must be followed. And if a defendant is going to admit liability and going to say, look, I caused the accident, well, that removes the plaintiff's ability to cast aspersions at the plaintiff, and that's a wise strategy decision for a plaintiff to make.
Isn't that exactly what happened in the Van case?
The Van case is an interesting study in jurisprudence, Your Honor. It's
factually indistinguishable, right? I mean, in Van, all the experts said that the injury was causally related. I mean, you had the same set of facts, a minor, arguably a minor bump, and the argument against causation was that it was a minor accident, right?
The issues addressed by the Supreme Court focus primarily on the actual standards of review for the courts to review.
But at the end of the day, they sent the thing back to the trial judge to make the decision about whether to grant a new trial or not. They didn't order a new trial as a matter of law.
Correct, Your Honor.
And you're telling us that we have to order a new trial as a matter of law.
It's not me that's telling you that, Your Honor. It's this court's own decisions in Ridenour versus Sherrick and
Van tells me that on facts similar to your case, that the question of whether or not a verdict is against the manifest weight of the evidence is a question for the trial judge.
The Van case does make the direction that the trial judge needs to consider it in light of the appropriate standards, and that's...
But if it was a case where the plaintiff was entitled to a new trial as a matter of law, the mandate from the Supreme Court would have been to direct the first DCA to I can't remember what the trial judge did there, but affirm the trial judge, I believe that's what they would have said, affirm the trial judge. Trial judge ordered a new trial, so, that's the right result, right?
And of course, we don't know some of the specific issues involved in that case or what was argued because they kind of got permutated into other jurisprudence issues as that case rose up. The cases that do give this court more direct guidance on what to do for this specific kind of case are those cases that dealt with specifically this issue, not just this court's decisions in Ridenour and Peak, where this court was very determinative that there is no gray area here. If the medical testimony is unrebutted.
Your appeal got worse after Van got out, Counselor. I mean, below the trial lawyer relied on this case out of the fourth, which, Van upset in this decision, and
The Keebler versus Ferris case, but the Keebler versus Ferris case was simply one of many. In the upsetting of that case there was nothing in Van that directly said all of these cases are wrong on their law. The problem with the cases was the way that the judges were being given in some district courts of appeal deference for legal determinations on a motion for a new trial.
well, are you asking us to send the case back for the trial judge to make the manifest weight of the evidence weighing analysis?
Your Honor, we are asking this court to do what the court in the Second District Court of Appeal did not once but twice in Ketsky versus Small and Martin v. Brubaker. We're asking this court to do what this court has already done in multiple cases in Hartsfield, in Peak, in Ridenour, and to direct the court that under these circumstances, where there's unrebutted medical testimony, where you may have used the credibility appropriately to diminish your damages, to cause the questions of fact to come out, to greatly make it where a jury is going to give a whole lot less, but you can't give zero. Zero is logically inconsistent with that testimony. It's not the way that the law is supposed to be. All of these cases have held that in the past. Van does not reverse those cases.
On remand in Van, the trial judge decides that a new trial is not appropriate. I mean, that's what the Supreme Court said the First District is supposed to do. Send it back, do a manifest weight of the evidence analysis. So let's just assume the trial judge says, no, a new trial is not appropriate. What should the First District do when that decision is appealed again?
Your Honor, that's a question that, of course, that court's going to be confronted with, because the problem is...
Doesn't the Supreme Court say that as long as reasonable people might differ on that, trial judge is entitled to broad deference?
I would say that the Supreme Court said that the wrong standards were applied below. The wrong standards were applied on appeal. The wrong standards were applied throughout. Let's try this again. And when it comes up, I don't think that the matter is predisposed to be determined, that the court wants to know, well, let's see what happens when the right standards are applied. Here, we have examples of right standards.
So they sent it back as it's a hypothetical exercise.
I wouldn't go that far, Your Honor. It's clearly more than hypothetical for Mr. Van and the parties in that case. It'll make for great importance. Of course, the hopeful thing is the judge gets it right on remand, but they're saying that it's important. The jurisprudence is important to make sure that the steps are followed in the right order, and it's my belief that that's why the court accepted that case, why Periente wrote this long opinion discussing those jurisprudential issues involved, that's what that case is about. They were not clear on these issues, that these other cases that both parties have been discussing throughout these briefs.
Did you get the supplemental authority that counsel?
I did, Your Honor.
What do you think about that?
It's interesting. I'm not inclined to find that the fourth DCA's analysis, including these new 4 criteria by which you can pull out from the general rule, should apply in all cases. That I will say this first. It's important to note that case notes that the general rule is what we've been talking about here, that the general rule, what he calls the per se rule, is that you get damages when the other side admits liability and there's no contradiction in medical testimony, including the defense IME. The 4 exceptions that they give are interesting, though. Let's look at them for just a second. Pre-existing extensive medical history, that, you know, there's definitely a difference between, I had a visit 5 months ago, but I didn't treat, I'd never had a surgery, any of this, versus other cases that this court or other courts have been confronted with where, oh, by the way, I had a major spinal fusion that I never told anyone about. There's a big difference there. A second question is a lack of candor, and obviously that is an issue involved in this case according to the arguments, but there's a difference between lack of candor that then does not result in any effect when you allegedly don't tell your doctor something and then the doctor is confronted with, well, if you were told this, would it have made a difference? And the doctor goes, absolutely not. Dr. Roberts says, absolutely not. Dr. Natalia says, absolutely not. All of our doctors say, no, this makes no difference. Dr. Mancuso, the defense IME, is not provided with any records that makes him say, well, oh, in light of that, I do change my record. Nobody flips, and the cases that do find an exception to the general rule often have one of two things. Credibility such that an expert flips, makes a new opinion because of, wow, if I had known that, that would have made a difference. Instead of here, where the plaintiff's treating physicians, and these are treaters, not testifiers, steadfastly go, no, that makes no difference to
That
me.
happening in Van.
I don't recall that being an issue in Van, and that's part of the issue here, that Van didn't necessarily flesh out some of these issues.
Oh, my gosh, did you, I mean, look at this opinion, it
It is long.
it took me hours to read, and they've got every expert's testimony in there, you know, I mean, it's...
I agree, Your Honor, and there wasn't a flip in that, but that's, in my mind, not what that case came down to. To return back to that fourth DCA case, the other two things are even more compelling in this case. The third of those prongs is videotaped evidence, surveillance. It seems that the majority of cases where they say, here's the general rule, but we're going to find an exception here, it's because, guess what? We've got you on surveillance lifting heavy drums into your truck, doing range of motion movements that defy what your doctors say. That is kind of a de facto medical testimony. Well, doctor thinks this, but a picture's worth 1,000 words. We've got it. You know, that is allowed to be the ace that trumps in. And obviously, there is no surveillance of any sort in this case. And then the last is, according to the fourth in those decisions, that in the PAC decision, which actually went the other way but used the same four-pronged test, a conflict of expert medical opinions. If you've got that conflict of expert medical opinions, you really shouldn't be in this this situation anyway. That if you've got that prong, you're probably not going to lie here. So because...
So you think that case is distinguishable?
I think that case is distinguishable, and I think if one looks at the rubric, it's actually not necessarily disadvantageous to the position that's being espoused here. I don't think this court needs to follow that. I think that the standard this court has already set in Peek and Ridenhour, and what the second has said, much simpler and clearer in Ketsky and Martin, simplicity makes for much easier following case law. The problem with those criteria is it allows the exceptions to swallow the rule, that, trial judges could say, well, look, you have somebody said something different to a doctor once 30 years ago, that's enough. You've got an exception. These are cases, all of these cases are cases where a jury heard unrebutted medical evidence and still told a plaintiff, no, you get absolutely nothing. Obviously, these cases must involve credibility issues, must involve issues where the plaintiff gave those juries reasons not to like them. There have to be inherent credibility issues. And if that's the case, having all four of those exceptions open where any one triggers this exception to the rule means there is no rule. The exceptions now rule it. So as much as that fourth DCA case, I believe, does not hurt us, I think that this court should not adopt those standards. Your Honor, I would like to, at this point, save the rest of my time for rebuttal.
Got over 7 minutes.
Thank you.
Yes, sir.
Good morning. May it please the court. My name is James Wachowski, and I represent Mary Tucker, the defendant and appellee in this case. I apologize for my voice. I'm a little bit under the weather, so my voice is not normal, and I'll try my best to be clear. If you don't understand anything I say, please ask me to clarify, and I will. First of all, Judge Thorpe, I think you're right about the fact that Van applies directly to this case. The facts are similar, the situation is similar, and basically the only difference in Van versus this case is that in Van, the trial court applied the wrong standard because the Van trial court said, well, the jury could not reject the unrebutted testimony of the experts, even though there was other evidence on the record, which was thoroughly discussed by the floor of the Supreme Court.
Did the trial
that would allow
judge here
that.
do a manifest weight of the evidence analysis?
I'm sorry?
Did the trial judge here do a manifest weight of the evidence analysis?
The trial judge here did, and what he did specifically was do what the plaintiffs requested below. And what the plaintiffs requested below at the trial level, when they filed a motion for new trial, is for the trial court to reconsider the denial of the motion for directed verdict. And that's the core of their argument below. That's the core of their argument in their initial brief. In essence, that the trial court should have granted the motion for...
The trial judge didn't do any weighing himself, did he?
Well, he did discuss a lot of issues about the credibility of the plaintiff, about the fact that this was a very minor accident.
What the jury, he speculated as to what the jury's rationale might have been, but he didn't do any of his own weighing, right? Didn't say, well, I didn't believe the woman, I'm not going to give her a new trial because I don't believe her. He didn't do that, right?
No, he wasn't asked to. That's the bottom line. He wasn't asked to do that, but he made comments throughout if you read the hearing of the motion for new trial, throughout the hearing, he makes several comments that indicate what? That a reasonable jury could have found the verdict that they found. And obviously from the comments of the judge, I think he made very clear that he felt that this was a very weak case, that this was a very minor accident, that the plaintiff had no credibility whatsoever. And even though, yes, he did say at times, well, that was a decision of the jury that they didn't believe her, he made some statements like that. But I think that if you look at the overall the discussion that was occurring at the trial level, from the beginning of the hearing to the end, he made it quite clear that the jury's decision was quite reasonable in light of all the evidence at trial. So, did the plaintiff below ask the judge to apply the standard, and did they argue, well, look, there's all this evidence that contradicted the medical experts, yet the manifest weight of the evidence is that she was at least partially injured? They never said that. They didn't say that in their motion for new trial. They didn't say that at the hearing of the motion for new trial. They didn't even say that in their initial brief in this case. In the initial brief, you're not going to find any facts whatsoever about the contradicting evidence. All that they say is, well, all the experts agreed, therefore, as a matter of law, we should have gotten some money, and now give us a new trial on all damages. So that's how I would respond to that. I mean, I think that if there was an error in not applying the manifest weight of the evidence, it would have been an invited error because that's not what the plaintiff was asking below. Plus, I don't think that there was any legal error at the trial level. Just like in Van, the trial court erred. Why? Because the trial court felt that even though there was, other lay evidence that contradicted what the experts said, the trial court in Van said, well, I cannot, the jury could not have gone against what all the experts said. Well, the Florida Supreme Court said that that's error. And basically, for you to reverse here, you have to basically you have to commit error, and you have to say that the trial court committed error by doing the opposite, by saying that, look, there's all this other evidence that was presented at trial that contradicts what the experts said. And even the defense expert, he said, well, I'm going to give her a benefit of the doubt diagnosis and say, well, she suffered a sprain, assuming that whatever she says about pain after the accident is true. But I think that he basically left that question for the jury to decide, and in the closing arguments, that's what the defense counsel argued, that there's all this other evidence of what it looks like fraud. This was kind of like a fraud in the court type situation where it was left for the jury to decide, and I think there was sufficient evidence for the defense counsel to argue to the jury that the plaintiff was a liar, that the plaintiff was making up the fact that she was injured in this accident, when there's evidence that just a couple of years before she had a much more severe accident, where there's evidence that 6 months before she had been getting treatment for her shoulder and neck, and there's evidence from the testimony of our client, Ms. Tucker, that immediately after the accident, this lady comes out of the car and says, oh my my gosh, I have neck pain. I never had this kind of injury before. I mean, that kind of, when a jury hears something like that and sees records from 6 months before that this lady went to the emergency room, that she was in severe pain and she was seeking treatment for neck and shoulder, the jury was not going to believe her. And I think that the judge properly upheld the verdict because there was overwhelming evidence that the plaintiff was not truthful, that the accident was very minor, and that supported the finding that, in essence, the jury could conclude that plaintiff suffered no injury at all in this minor accident. And I don't know if you want to discuss all the other cases. There are obviously a variety of cases that gives this general rule. They don't discuss in detail. You know, sometimes they don't discuss the type of accident involved. Sometimes they don't discuss whether there was any credibility issues involved. And they just make a general statement that if there's no, if it was a reasonable trip to the emergency room, and they use the term reasonable without explaining what happened, or if there is an agreement between all the counsel involved that there was at least some injury but a dispute as to the extent of that injury. In those situations, the plaintiff must get some money because there was no dispute of an injury. Like, for example, there was a case where I think a lady was in the store and a shell fell on her head. An ambulance was called. She had to be taken to the ER. In the end, I think that she claimed a lot of injuries were related to this incident, and the jury disbelieved her. So the appellate court affirmed on causation, but still said, well, there was no dispute that this lady got injured at the store, that the shell fell on her head, that she had to be taken to the ER by ambulance. So, and you know, there are some circumstances where I think that the evidence will show that at least some minimal amount of money must be awarded. But then there's a plethora of cases from pretty much all the DCAs that discuss a situation like ours, like the one in Van, when there is on the one hand, you know, an accident, and on the other hand, a whole bunch of evidence that was presented to the jury that would demonstrate that there may not have been any injury at all. And in those circumstances, I think it is proper to affirm a verdict, a zero verdict. Any other questions?
No, sir, thank you.
Thank you so much.
Thank you, Your Honor. First, to return briefly to Van, I had talked in my discussion of other cases about a case where, to distinguish that case from our case, someone had actually had a cervical fusion surgery done, and how obviously markedly different that would be from a situation where someone had gone to an ER once 5 or 6 months ago for complaints and didn't return. That case was Van. Van has, if you want to go back to that 4th DCA case and look at their factors, Van has that extensive pre-existing. When we're talking about not disclosing a cervical fusion, that's huge, and that would make it the kind of case that pulls it out of the general rule. But the argument that we just heard, that there's a plethora of cases that go against the general rule, more so than exists in the general rule, that makes no sense. That defies what general means. And in fact, an analysis of the cases shows that case after case that gets an opinion is the kind of case where they say, look, we understand the broad discretion the trial court has to not grant a new trial or to grant a new trial, but an exception exists when a jury awards zero damages on a case where there's unrebutted medical testimony and the defendant admits liability. And Judge Altenberg on the second, wrote not just one but 2 opinions on this exact subject, and wanted to make it clear that we write in this case primarily to remind defense attorneys that it is not safe in this type of action involving the no-fault threshold to tell a jury it can do what it wants to do. Here, they told them not you can do what you want, but they were directed by opposing counsel in closing argument, you must say no to this, and basically put all the eggs in the basket that was the reversible basket instead of putting the eggs elsewhere.
That was the manifest weight of the evidence argued in the motion for new trial?
It was definitely raised, admittedly it was raised more in the sense of this flavor of it. it's so manifest, it's unrebutted. But that is what the motion for new trial is. That is the manifest weight of the evidence standard. It's just the manifest weight becomes the total weight of the evidence is against the defendant on the singular part of the damages involving before her surgery, the part that even their expert agreed to. So it wasn't a manifest weight as much as a total weight, but it's a lesser included. The manifest weight was absolutely argued. The standard was put before the court, the Stuckey case was cited to the court, the argument was there, and this court would be appropriate to reverse, if for no other reason, on the court's failure to properly follow that through. We admit we do not relish returning to this particular court for a further decision on that issue, but if that is the reversal this court has in mind, then that would be appropriate. We believe in instruction as to what that court should do to follow this court's guidance in Ridenhour and in Peake versus Stevens, to follow the Second District Court of Appeals, clear discussions, to even follow the Fourth if this court were so inclined with its new four-pronged standards. Whatever this court decides should be the clarified law of this court. That reversal should be inclusive of a direction to the lower court to follow it. Here, where Ms. NIEDERHELMAN went to the ER that very day of the accident, where she has been treated consistently by doctors who have repeatedly said, you can bring to me these additional facts, they don't change my opinion. Where Dr. Mancuso, the expert for the IME, says, I found her to be an accurate historian to me. I found that she was, reasonable and acted appropriately and didn't exaggerate to me. He answered all of those questions grudgingly, but answered them all consistently. That he did the physical tests on her, did the palpable tests and all of the various, and he went through each of them. And she didn't have exaggerated motions or the other kinds of things that give doctors the knowledge that, okay, you're not shooting straight here. Here, he didn't testify to any of that. And interestingly, where they keep talking about, well, but it's all subjective. Well, they didn't provide their own IME expert the objective evidence that Dr. Roberts, the surgeon, had taken. Dr. Roberts takes the photographs, and you can use the photographs and look at the photographs and say, well, here's what it looks like if it's degenerative, here's what it looks like if it's not, and in the part of the shoulder where the surgery had to be, it's not. Well, why doesn't that photo taken before Dr. Mancuso ever does his 3.5-minute IME, no, that photo doesn't get given to him. The deposition transcripts don't get given to him. The evidence that would give him the ability to see objective findings in addition to his own physical tests that he does on her, he's not given that. So for them to then be able to hide behind that shield to go, our expert didn't have it, there's nothing to be done, it's just not enough to escape the logical, sensible, reasonable cases that have been decided by this court, by the second court, and by the sister courts throughout Florida that hold this general rule to be what the rule should be. So for that, we ask for the reversal from this court, and thank you for your time.
All right, thank you for your arguments, and
Thank you, gentlemen.
be in recess.